Good morning, Ms. Miller. Mr. Thompson.
Good morning, Chief Justice Marshall, Associate Justices. May it please the Court. My name is John Thompson. I represent Frederick Murphy in this appeal of a first-degree murder conviction. Mr. Murphy was convicted in a 1999 trial for the August 2nd, 1993 murder of Courtney Arar, a man known as Spliffy, who was shot to death as he walked along Andrew Street in Springfield around midnight that night with a man named Paul Smith, who was also known as Guetta. The issue in the trial was the identity of the killer. There was no physical evidence that linked Murphy to the killing, only the testimony of two people, Smith, who was with the victim when he was shot, and a man named Harold Wilson, who was a jailhouse informant and testified about admissions that Murphy supposedly made to him. A key role in the case was played by a man named Derek Riley, also known as Randy, and an organization known as the 90s Posse, which is a Brooklyn-based Jamaican drug gang. For the Commonwealth, Riley and the 90s Posse provided the motive for the murder. According to Wilson, Murphy told him that he had killed, or actually didn't say that he'd killed him, but he told him that his acts against Arar were retribution for Arar's paying tribute to Riley and the 90s Posse. For the defendant, Riley and the 90s Posse were the parties responsible for the murder, and Murphy attempted to present evidence that the murder was ordered or carried out by members of that organization. I have 5 claims presented in the briefs, and I'd like to talk about 3 of them today, beginning with the claim that false testimony was deliberately presented by the Commonwealth regarding the agreements between itself and Harold Wilson, the jailhouse informant. There's no question, it's uncontested at this point that both the federal government and the Commonwealth had an agreement, a quid pro quo.
Do we know when the agreement was entered into?
We know that the agreement between the federal prosecutor and the witness was entered into in October of 1998, and that the interaction that led to the supposed admissions by Mr. Murphy began the following month in November of 1998. We don't know when the agreement between the witness and the Commonwealth was formed, but we do know that it was in effect at the time that he testified at trial.
Were the terms established at the time the agreement was entered into?
Justice Ireland, some of the terms were established. There was a written agreement between Mr. Wilson and the U.S. Attorney's Office.
An agreement to do what? For what?
An agreement to cooperate with the government in exchange for a reduced sentence. And that agreement was actually carried out. Wilson faced a sentence under the federal guidelines of a minimum of 100 months. At the time that he had his interactions with Mr. Murphy, he had pleaded guilty but not been sentenced. His sentencing was postponed explicitly to allow him to do his cooperation. Following Mr. Murphy's trial, the federal prosecutor asked the federal judge to depart downward from the guidelines, and that was done on the basis of the state prosecutor's, Assistant District Attorney Donato's, representation to Mr. O'Regan, the federal prosecutor, that Mr. Wilson had been instrumental in the conviction of Mr. Murphy.
Your argument is that this comes under the scope of Commonwealth versus Reynolds because the Commonwealth's promise was more than an unencouraged hope to curry favor. Rather, it was an articulated agreement containing a specific benefit. That's your contention.
And I think, Justice Cowan, that's what the record shows very clearly. There is some vagueness about the specific details and the circumstances under which the agreement was entered into, but it's very clear that there was an agreement, and the trial judge found that there was an agreement and that the agreement was carried out.
Well, the agreement had nothing to do with Mr. Murphy, right? It wasn't an agreement to cooperate against Mr. Murphy.
It was not directed at Mr. Murphy. That is, the agreement between the federal government and the witness was not directed at Mr. Murphy. The agreement between the Commonwealth and the witness was directed at Mr. Murphy.
And we don't know when that agreement, when the Commonwealth joined the agreement, right?
We don't know that, Justice Cordy, but we do know that that shortly after his agreement was made with the federal authorities, Mr. Wilson, who was a convict, was placed in a pretrial unit that Mr. Murphy was located in, what is referred to in the record as a pod.
Well, assume for a moment that the Commonwealth didn't become an explicit party to this until they were informed that Mr. Wilson had developed some information that might be of interest. Yes. Assume that for a moment. Prior to that time, why is it that we can consider Mr. Murphy to be an agent of the Mr. Wilson to be an agent of the Commonwealth?
I think before he agreed to testify on behalf of the Commonwealth, we don't have evidence that he had any agency relationship with the Commonwealth. But it's clear that he was an agent of the federal government, and it's also clear that there was an agreement of some kind.
I take it your point, Mr. Thompson, is that for purposes of whether or not you're an agent, it doesn't matter which aspect of the government it is for which you are an agent. You're an agent, correct?
I think that's our position, Justice Marshall, although I think on the facts of this case, it's clear that the Commonwealth joined in agreement with the...
No, I understand that, but one could have... Let's assume the Commonwealth hadn't joined.
Yes.
But there's a finding that he was at the time an agent of the federal government.
Yes.
He is still an agent of the government, correct, with the government eliciting, soliciting, obtaining, seeking information, correct?
That's correct, Justice Marshall. And I would say that that at the time that he spoke with Mr. Murphy, he was violating Mr. Murphy's Sixth Amendment rights on behalf of the federal government.
So I suppose your argument might be if there's a violation of that right by the federal government, which leads to the disclosure of incriminating information,
yes,
then that's, in essence, sort of the fruit of the poisonous tree here, and the state can't then use it?
Well, it might be considered a reverse silver platter doctrine.
No, I mean, isn't it more straightforward than that? Assuming that somebody is in state custody and the defendant's Miranda rights are violated by a state law enforcement order, and then for whatever reasons, perfectly legitimate, the federal government takes over the prosecution, you still can't say, well, you can use that evidence.
It's still inadmissible evidence.
It's inadmissible
evidence. Yes, Justice Marshall, no matter which government agency or which government violated the Sixth Amendment. It's still a Sixth Amendment violation. And the evidence is inadmissible under federal law and under Massachusetts law.
Yes, otherwise you have, you have the federal government not deliberately violating somebody's Fifth, Sixth, whatever rights are, and then you say, well, we can't use it in a federal prosecution, so we'll hand it over to the state to prosecute. Can't possibly do that.
We have the kind of cooperative interaction that's seen in this case is common among the federal and state authorities.
Well, we would hope it is common because, you don't want to have bright lines between law enforcement agencies, but it means that, what's good for the goose is good for the gander as well.
That means that they have to observe the constitutional limitations in their dealings with each other as well.
Can I just ask you about the testimony at trial? Was there one representative of the district attorney's office who had negotiated either with the federal government or with Murphy or whoever it was with respect to the cooperation after the information was obtained, or let's assume it was after?
It's not clear exactly how that interaction worked, Justice Marshall. From the record, what we know is that when the federal prosecutor made his sentencing presentation, he said that Ms. Donato, the prosecutor in this trial, was the one who informed him that Mr. Wilson had been instrumental in Mr. Murphy's conviction. So we don't know. What Mr. Wilson said was that after he had talked with Mr. Murphy, he went to his lawyer, Mr. Williams, and Mr. Williams took over from there. We don't know who Mr. Williams dealt with, but we do know that, and the trial judge found, that at the time that he testified in the trial and Ms. Donato represented that the Commonwealth had no way of rewarding this witness, that the agreement was already in effect. And as a matter of fact, when the hearing occurred on whether Messiah had been violated immediately before the trial, Mr. Williams told the trial judge that Mr. Wilson needed to testify in this case in order to get his reward from the federal authorities.
How did the state find out about Wilson's information?
Federal government went and told them.
We're not sure exactly. Wilson said that he talked to his lawyer, Mr. Williams, and that Mr. Williams handled it from there. So we're not sure.
Let me put it this way. If the federal government has sent somebody in somewhere to say get information, whether or not it was directed at Murphy, correct?
Yes.
And William knows that as part of his agreement with the United States government that he obtain information that might be helpful, generally speaking, in law enforcement, correct?
Actually, it was more specific than that, Justice Marshall. Wilson testified that his understanding of what he was supposed to do to cooperate was to get information to help convict somebody.
Yes. So he gets some information.
Yes.
Correct. And he probably doesn't call up he's represented by counsel. He's going to talk to his lawyer, I assume.
That's what he said. And
his lawyer, acting as his agent, as the client's agent.
That's right.
Contact somebody who represents the United States government.
He said, well, I'm not sure whether he contacted someone who represented the government. This was the lawyer who represented Wilson in these dealings with the Commonwealth was his defense lawyer in the federal case. And so he was likely the bridge. He was likely the connection between the two. But the record doesn't show clearly how that transaction was developed.
Now, I take it your position is that because the fact that he's an informant, the fact that he hears information is certainly not sufficient. I take it your position is that he, by questioning Mr. Murphy a little further about the details of what he had done, that he, in fact, elicited the information as opposed to simply hearing it as someone in the same pod.
That's part of my position, Justice Cordy. The deliberately elicited standard that's used both by this court and by the Supreme Court is a broader standard, or is covers a broader range of activities than simple interrogation. I think that it's clear from the Supreme Court Messiah line of cases that there is a strong that the break between what's permitted and what is not permitted is totally passive listening. That is in Coleman versus Wilson, which is the only Supreme Court Messiah case that has found that information was not deliberately elicited. It was a listening post case, that is, where the informant did not even engage in conversation, but only listened to what the suspect, the defendant, had to say. In every other case where there's been conversation about the subject matter, about the case that the defendant is represented on, the Supreme Court has said that that amounts to deliberate elicitation. The Henry case, which I've discussed extensively in my brief, is very specific on this. And the general principle is stated in Maine versus Moulton, and it's also stated in this court's case of Commonwealth versus Henry. The principle is that once the defendant has counsel and has invoked his right to counsel, all interaction between the government and the defendant has to go through counsel. And any kind of device that gets around that and elicits information that's incriminating to the defendant is a violation of the Sixth Amendment.
So did the judge find that there was a conversation between Wilson and the defendant, or did he find that Wilson was just listening?
He found what he found was that all of the interactions between Wilson and Murphy were initiated by Murphy. But in Wilson's own statement, the key phrase or the key admission that he reported was the result of a question that he put to Murphy. Okay. What did you do about that?
And did the judge so find?
The judge did not find that. The judge made a note that this information was in his statement, but he said that what Wilson had also said was that he was surprised that Murphy said this, and therefore it wasn't deliberately elicited. I think that reflects the application of an erroneous legal standard, a
So
very narrow standard of what deliberately elicited means.
Yeah, and you're saying it doesn't really matter because there was a conversation. It was the product of a conversation.
That's what Henry says, Justice Spina, although I think it is important to acknowledge that, as a matter of fact, this most important admission, which was supposedly an admission that he killed the victim, was the product of a direct question. What did you do about that? Now, the issue has come up also. The trial judge found that the false testimony issue was waived by defense counsel. And I just want to briefly address that. I have two positions on that. The first is that this is not a waivable violation of the Constitution. When a prosecutor deliberately presents false testimony or fails to correct false testimony that she knows is false, there is the violation of the Constitution includes the failure to correct the falsehood. Napoo versus Illinois is very clear on that point. The violation of the Constitution is not simply the presentation of the false evidence, but it's the failure to correct it. The trial judge found here that defense counsel had a police report at hand in which concluded with a statement from Mr. Wilson saying that he knew that his cooperation would be brought to the attention of the U.S. attorney, even though the sentence right before it said, I have been offered nothing for my testimony or for this statement, either one. This information was not presented to the jury.
It wasn't presented to the jury, but wasn't there even a voir dire on this issue?
There was a voir dire on the Messiah issue.
But in that voir dire, wasn't it quite plain that what the deal was?
It seems from the record that it was quite plain what the deal was, because Mr. Williams, Mr. Wilson's attorney, had said to the judge, my client has to testify here to get his deal, and my job is to help him navigate around the defense counsel's cross-examination.
And trial counsel was present during this voir dire.
He was.
So
He
trial
was.
counsel had the information, surely.
He had
Police
some
report
information.
and voir dire.
But there was also the representation by Ms. Donato that the Commonwealth was not in a position to reward this witness in any way. That was made in that same hearing. And our position is that defense counsel was entitled to rely on that representation. In this situation where it wasn't clear what the facts were, there was a very direct, explicit representation by the prosecutor.
But wasn't it clear to the jury? I'm not talking about the suppression issue. I'm talking about the false testimony issue. Wasn't it clear to the jury that Wilson fully expected to be rewarded by a lower federal sentence, which he was facing, the only possible sentence he was facing, if he gave, quote, truthful testimony in this case?
The jury heard conflicting evidence about that, Justice Spina. What the jury heard was a presentation by the prosecutor which said, in effect, you have a deal with the government, but you don't have a deal with me, and you don't have a deal with the Commonwealth. And he said, that's right.
I understand that. But,
Yes.
but didn't the jury, wasn't it clear to the jury that if he testified, regardless of who was going to communicate his favorable testimony,
Yes.
that if he testified favorable to the Commonwealth in this case, that the federal government would reward him for that?
I don't think that was clear. I think that it was clear that he hoped that he might get some reward for that.
Okay,
But
all
what
right.
what the prosecutor was arguing was that that was a groundless hope. That is, that his deal is with the federal prosecutors, and we're not connected with that at all.
I
And if the
take it
federal
that-
prosecutors do that,
I take it that one of the problems here is that if I'm sitting on the jury and the Commonwealth of Massachusetts is prosecuting somebody for murder in the first degree, they don't know what Wilson may have a deal with the federal government on some other crime that may have been, alleged crime that may have been committed.
that's right, Justice
No,
Marshall.
that's not right. The jury was told that he had pending federal charges, and he was awaiting to be sentenced on those.
They were told they were told both that he had pending federal charges, which was not true, and that he was awaiting to be sentenced. He was convicted and awaiting to be sentenced.
Okay, on federal charges.
On federal charges.
And his performance in the case in the Commonwealth, in this case in the Commonwealth of Massachusetts, could have an effect on that sentence in the federal court.
That's what the jury didn't know, and that's what
They didn't know? Well,
the
what-
Commonwealth denied. The prosecutor denied, that is, it drew a distinction between the Commonwealth, a deal with the Commonwealth, and a deal with the federal government.
Okay.
But-
The prosecutor drew that distinction.
Yes.
But the jury understood that the federal government was willing to reward him for his performance in the state court case.
That's not clear.
That's not clear.
That's not clear at all. But
Well, how is he going to get rewarded?
That's the question. I think that's what the Commonwealth was trying to throw up here as a smokescreen, is that while he might have had a deal with the federal government, he had no deal with the Commonwealth. He had no deal with the prosecutor personally.
Mr. Thompson, I take it your point is the following. They know, the jury know, correctly or incorrectly, that he has pending charges in a federal case.
Yes.
And he has a, quote, deal with
Yes.
the federal government. That deal might be that he act as a witness for the federal government in that case. It might be that he informed the federal government about other participants in the case. I mean, there's a whole set of criminal activity which the federal government is interested in.
Yes.
Who knows why he's here? He happened to be a cellmate, correct?
That's right.
But he's got no deal, the jury thinks, with the Commonwealth.
That's
So
very-
what he says in this case isn't going to make a whit of difference because this is not a federal case, correct?
That's right.
That's your point.
That was made very clear. there's-
But the agreement was entered into evidence, and I take it was argued by the defense lawyer, that apart from all this, who's the deal with, his credibility was in question in this case because he stood to gain by testifying favorably for the Commonwealth.
That's right, Justice Speaker.
Okay.
And the suggestion was that that his testimony might be influenced in the Commonwealth's favor by this deal that he had.
With the federal government?
Yes.
Okay. So there was the carrot that was inducing him to testify the
Yes.
way he was testifying was presented to the jury.
It was, but the jury wasn't, and the defendant was entitled to present more, and the jury was entitled to know more. Once he
But
lied,
what difference does it make?
it makes this difference, Justice Spina. Once he lied to the jury, the defense was entitled to present that fact to the jury because that showed that his agreement with the federal government actually influenced his testimony in the case before them. It had an important impact on his credibility and on the prosecutor's credibility. The jury was entitled to know that the prosecutor had deliberately presented false testimony to them.
Mr. Thompson, am I correct? Is there a suggestion there that the prosecutor was somehow limiting the question purposefully to do you have an agreement with me, or did I promise you anything, as apart from the Commonwealth, or am I reading too much into that?
She elicited both facts. That is, she asked him, "Do you have an agreement with the Commonwealth?" He said, "No." She said, "What kind of an agreement do you have with me?" "None." Both of those. She said also, "You understand the difference between the federal government and the Commonwealth?" And he said, "Yes." In other words, the division between the two was explicitly drawn out in his testimony, and the fact that he understood that there was the federal government on the one hand, there was the Commonwealth on the other hand. His agreement was with the federal authorities. He had no agreement with the Commonwealth. He had no agreement with her. This was all false. And the jury was entitled to know about this falseness in the Commonwealth's presentation because this was a crucial witness. This was the witness who presented the admissions that amounted to a confession, who reinforced the identification that had been called into question by what happened with the witness Smith, as we've laid out in our brief.
Thank you, Mr. Thompson.
Thank you very much.
Mr. McMahon?
May it please the Court, Catherine McMahon, Assistant District Attorney for the Commonwealth. In October of 1998, and it appears in the record appendix at pages 127 to 32, Harold Wilson entered into a written cooperation agreement with federal authorities. The terms of that agreement are in the record appendix, and they do not specify that he's supposed to obtain information from anybody They specify that he's to cooperate, that he is to testify truthfully. They did not mention any particular case. They did not mention any requirement that he go out and get information.
Well, why wasn't the statement a violation of the Henry case?
For two reasons that the trial judge found, both at trial and in reconsideration in the motion for new trial. He found, one, that Harold Wilson was not a government agent, and two, that even if he was, he didn't deliberately elicit anything from Mr. Murphy.
But he was acting as an agent for the federal government.
He had entered a cooperation agreement with the federal government which required him to testify truthfully. He testified that no one told him to talk to the
Testify
defendant.
truthfully about what?
It just doesn't say. It's just to testify truthfully if he's called to testify.
But he was there. He was in the Hampshire County House of Correction to garner as much information as he could.
No one told him to do that.
What was he doing in the
testified
Ham-
expressly that no one told him to do that.
But,
And there is
Mr.
no
McMahon-
evidence to the contrary.
So he was
McMahon-
just supposed to be like a vacuum cleaner and just
Well,
go out and wherever he got information, just,
He knew that it would be helpful for him if he did it, but he had no agreement or no instruction from federal authorities to do that.
Mr. McMahon, let me step back. What was he doing in the House of Correction?
He hadn't been sentenced yet, and
Hadn't been sentenced by whom?
the only charges he had were federal charges, so he would have had to be,
So, wait a minute, we put him in he's been convicted.
but the conviction isn't final because he
Well,
hasn't
he's
been
been
sentenced.
convicted. The trial, whatever evidence was going to go in to convict him, whoever he was going to finger or not finger, that's done. So he's awaiting trial, and he's just sent there, so sometime in the future, when he stumbles across the fact that the timesheets filed by the prison guards are inaccurate or, whatever it is, it's going to be just fine. As long as he just, whatever he sees, that's absurd, isn't it?
He was there, he was in, I think, the Hampshire County House of Correction before he pled guilty, and he was at the Hamden afterward.
Let me put it this way.
And there's nothing in the record
Let me
about
put
why
it
he was housed in the state jail system pending the resolution of his federal
Let me
case.
Well, that's not unusual. The
No,
federal
it's not
prisons are held
unusual,
in the
and there's
counties
nothing
all
to
the
show that
time.
it was orchestrated so that he could get information from anybody.
Mr.
There is-
McMahon, hold on one second. Assume that the federal government, for very good and sufficient reasons, has concerns that there are violations of the securities laws in various brokerage houses. And so it takes 10 people and sends them in to be employed by those brokerage houses just to see what's going on. If they see anything, and if they're prepared to testify truthfully, they're going to get some good reward from the government. You're telling me that they are not a government agent?
Oh, they're deliberately sent in there. That's what they know they're
No,
going
you've
to
got
do.
an agreement.
Oh,
They're not
there's an
deliberately
agreement.
sent. They're not deliberately sent in. None of them sent into this firm versus that firm. They've got 10. They've got 10 people. They send them to any house of correction.
With what kind of instruction?
You just.
Well, I thought the instruction in this case, as Wilson testified, and I may not have the quote right, but my job was to get information to help convict people.
No, he was asked what the definition of cooperation was, and he said it would be a good idea for me to get information about other people.
To help convict people.
Yes, but
Well,
there
let's
was
say
no.
to cooperate.
That's what he was sent in to do.
Explicitly, more than once testified. No one told him to talk to any inmate. No one told him to
Did
give
anyone
any
tell him not to
information.
talk to any inmate who's represented by counsel? The government now says, you're our guy, you got 6 months to come up with
They
information.
didn't say that.
Oh, they
no,
didn't?
that's what the defendant has been hoping to show throughout the voir dire, throughout the trial, throughout the motion for a new trial.
What did the prosecutors say
And-
at sentencing, or at the plea, that the sentencing was going to be postponed for, what, 6 months, so that Mr. Wilson could cooperate and get information for them and prove his worth?
That's not exactly what he said.
What exactly did he say?
The transcript is in the record.
Okay.
But
Was that the gist of it? Isn't that what these things always are?
I think Mr. Wilson and his lawyer, he was a savvy person, and he knew that
And the
a
government
lot
is-
of
and the
jailhouse people
government
are
is
who've
not-
had records, that it is a good thing if you can get information about other people.
The government
but
does-
in Messiah and Wilson and Henry and in all of those cases, there's been some kind of instruction or some kind of an agreement between the government and the jailhouse informant targeting at a specific individual.
And so this agreement had a wink to it. You go in and do your best, wink. And now he's not out on the street gathering information. He's in a very limited, confined building. He's in the House of Correction.
I don't even think we could say there's an agreement, wink, do your best. There's a piece of paper that says cooperate and testify truthfully.
And what was he
When?
supposed to do?
For what? Truthfully, about what?
Apparently, he had a co-defendant. We don't know from this record what his own federal case was involved. I know that there was a co-defendant.
But put it this way, even if he was a federal agent, in that case, he is a federal agent.
In terms of testifying against the co-defendant, I don't know, but what if...
It didn't say that.
It says testify truthfully. So what if that meant I'm going to be testifying against my co-defendant, I have to testify truthfully? How does that turn into an instruction to, while you're in the House of Correction...
What evidence is there in the record that there was a co-defendant who hadn't yet been tried?
There was evidence in the record that was a co-defendant. There's not...
Is there any evidence that he was going to be a witness in that trial?
No, and there's no information
And don't you
about
think we
that
would
other
have
than
a-
his plea.
Isn't it clear that when somebody's going to testify against a co-defendant, those agreements tend to be pretty specific?
No, I think this is pretty much a standard, from what I understand from the trial prosecutors, that this is pretty much a basic standard boilerplate federal cooperation agreement.
All right, you've read the transcript of his sentencing hearing, so what other cooperation was he given credit for?
Getting another inmate to come forward about somebody else about a murder
Inmate where? From where?
in Springfield.
House of
In the House of
Correction?
Correction.
That's correct.
In the House?
Yes.
All right, so let's assume that this prosecution, this murder prosecution, was a federal prosecution. What would you say about that? This prosecution was same facts,
Okay,
same facts.
I still don't see...
It's a federal prosecution.
I still don't see any conversation or agreement or instruction between a government and Mr. Wilson making him go out and get the information. I don't...
We want you to cooperate. We want you to earn credit, and to do that, you've got to get information and
That's
agree to
not-
this. Well, how the heck are you supposed to earn credit then? What's going on here? Let's be practical. What's going on here?
Practical, there are plenty of quotes in the law on this issue about a number of people knowing on their own that in order to curry favor, it's a good idea. This is an experienced guy in the system. This agreement, as the trial judge found, didn't require Wilson to get any information about anybody. There's nothing there in the terms of the agreement beyond that.
Isn't that the key piece? You cannot be an agent by just someone saying to you, you're my agent. You can only be an agent if you have very explicit instructions on what your authority is going to be. And here, he did not have such instructions, or at least the judge could so find.
No.
So once you eliminate that piece, then the next piece is, did the jury know enough about this whole situation so they could evaluate his credibility? And the answer to that seems to be they did.
I think they did. And there's a second factual point. In October, he makes the agreement with the federal authorities. He talks to the defendant, I think, in November and December.
Of 98?
Of 98. And I think it's after the defendant's been indicted, so his right to counsel had attached, no quarrel there. And it was after he'd signed that written agreement with the federal authorities. He tells his attorney what he found from Mr. Murphy. And somehow, either through his own attorney or through federal authorities, he speaks to Springfield police officers on March 24th of 99. I know Mr. Thompson said it's unclear when the Commonwealth got involved. There's a written statement. It appears in the Commonwealth appendix at pages 20 through 22, and it's a signed statement by Mr. Wilson detailing information that he received from Mr. Murphy. And this is the promise that he had from the Commonwealth. There haven't been any promises made to me for my testimony or this statement. I have been told that the U.S. Attorney's Office would be made aware of my cooperation. So the promise that he had from the Commonwealth was that the Commonwealth would let the federal authorities know about his participation in Mr. Murphy's case. And it was clear to the jury, despite the fact that the jury didn't know that we were the conduit of the information of, he testified that we were supposed to tell the federal authorities about it, that he was testifying in Mr. Murphy's case because he hoped to get a benefit from very serious federal offenses. Defense counsel went over the cooperation agreement and the sentences that he faced line by line with him, and had him explicitly state that he knew he had to cooperate in order to get the benefit of the federal sentence.
So what did the Commonwealth promise him?
To tell the feds about him
his
testifying.
cooperation?
Yes.
Okay, and that was clear at the trial. That came out. The prosecutor elicited that. That was clear.
No.
That's what he testified to.
No, there's a mistake. The prosecutor said, do you have any agreement with me? Do you have any agreement with the Commonwealth? No. What was the agreement? The agreement was to tell the federal authorities that he cooperated. But it was clear to the jury that he was sitting on that stand and testifying, hoping that his testimony would result in a break on some very serious federal charges. So yes, there was a falsehood. But no, it wasn't something that impaired the integrity of the jury's verdict, because it was the big thing, the big agreement he had was that he was going to get a benefit from the feds for testifying in Mr. Murphy's
Well,
case.
it strikes me that these are very delicate issues, and the prosecutor should not be eliciting what is clearly false information.
I absolutely agree with you, Your Honor.
What do we do about that? You're saying it's no prejudice here because
There's no
it
prejudice
generally
here.
worked
No,
itself through.
She was wrong. It's a falsehood. She elicited a falsehood. She should have corrected it. Not only did defense counsel have this agreement, it was given to him by the prosecution in discovery. It's the discovery Bates numbers on it. But neither she nor defense counsel went further on it. It was inaccurate testimony. That's what the trial judge termed it to be. It's an error, but it's because the jury knew what the big agreement was, with the big benefit, and that was who was going to make the telephone call to the feds so that they would know about his cooperation. But the cooperation itself was going to give him the benefit. The jury heard the big question, the significant question, as the trial judge found in denying the motion for new trial, so it didn't impair the verdict. She shouldn't have said that, or she should have said more. She should have followed up with another question or two. But the slip here wasn't enough to undermine the verdict, because the jury knew what Mr. Wilson hoped to get as a result of his testimony in the case.
That's not, well, let me say that if we agree with you on that, the message, at least one message in the case, will be to the district attorney's office that it's okay to play fast and loose.
No, I think you can write a decision saying, no, it is not proper to do that. But the next question as an appellate court is, if there's an error, is it reversible error? You know, that's your role here. It doesn't mean that you have to give your blessing to something that shouldn't be blessed. You can criticize it, say it should be corrected, whatever, but unless it undermine the integrity of the verdict, it's not a grounds for reversal simply to highlight a strong message that you should give. There was a mistake here. It shouldn't have been made. It was a false testimony. But the big picture was the right picture, and the jury got that big right message that he was sitting up there hoping to get a break on some very significant federal charges.
What's your best case on the question of agency here? I mean, we're not talking about an agent binding a principal in a commercial transaction. We are talking about someone who's been told that you will get a discount on your sentencing if your cooperation is worth something, and then his sentencing's postponed for 6 months and he's put in a jail. What is your best case that that doesn't make him an agent of the federal government when he does things that the federal government cannot do?
Contrasting it with Messiah and Henry and Coulson v. Wilson, and the other cases, as well as the number of Federal Circuit cases I've cited, and including this court in Reynolds, there's some agreement or instruction by the government to the jailhouse informant to get information from a specific individual. That it would be good for you to get to find a way to help us, but it's targeted at somebody. Whether, in Coulson, I can't pronounce right, versus Wilson, the person was only a listening post because he kept his ears open, but he kept his mouth shut. But nonetheless, he was directed towards that individual. So in that respect, because he was directed towards that person, you could say he was an agent because he was under instruction to go after a certain person. The second prong, deliberately eliciting, wasn't met there because...
Well, may I interrupt you? So is the reverse here that because there was no specific target, that everyone in the institution was a target?
And the federal authorities have rejected the concept of being like a giant listening post turning you into a government agent. It's an agreement. We don't have an explicit agreement here to get information from the population as a whole or from Mr. Murphy. He said, no one told me to talk to Murphy. Nobody told me to talk to anybody.
But
nobody told me to get information
but wasn't
from
he
anybody.
unspoken? If he didn't come up with something to talk about to the feds, then he wasn't going to be able to get favorable treatment.
That's true, but it doesn't turn this agreement. The agreement doesn't say go and get information from somebody.
Your theory is drawing a distinction between a specific agreement and a generalized agreement to get information from anyone.
Well, where's the general agreement to get information? It's to test what's expressed.
Is it testify truthfully about what? About the weather while he was in the jail?
It's a boilerplate agreement piece of paper that says testify truthfully. He wasn't the only person.
Testify truthfully about what?
Maybe his own case.
He had already been convicted, so we couldn't testify truthfully in his own
McMahon.
case. Let me just ask you another question. Excuse me, let me finish that. Is there any case that says that when, that draws the distinction that you make, specifically draws it, not inferentially?
There are the bright line jurisdictions, which I have, that require an explicit agreement. And I've listed 3 of them, I think, including the First Circuit. There are other jurisdictions that look at factors. It's not a bright line, but they still look to some kind of agreement or instruction, something pointing the person to, you are gathering information about X. And all the U.S. Supreme cases had the person targeted at a specific individual, either his co-defendant or cohort in the crime, or somebody specific that he was housed with in the jail for the purpose of listening.
Ms. McMahon, could I ask you this? Assuming that the agreement was that Mr. Wilson was to see if he could get information about Mr. Brown, and he's put into the pod where Mr. Brown is, and he is engaged in a conversation with Mr. Brown, and he elicits information, and absolutely no problem with that. You can't use it against Brown. But while he's in the pod, he has conversations with Mr. Murphy, most of which are initiated by Mr. Murphy, but there is the, whatever the question was, what did you do next, or, whatever the signaling thing was.
And questions like, what did you do next, or what did you
No,
do?
I'm just talking about agency here, for example.
Right. He was targeted after Mr. Brown.
Yeah, so
if
you
he
said-
thought, because, I'm going after
No, no,
Mr.
no, no,
Brown,
he's
it's
just
going to
in the
help
po-
me if I
No,
also
he's
go
a
after
government-
Murphy.
no, no.
It doesn't turn him into a government agent for purposes of Mr. Murphy.
So you're saying to me, somebody who is clearly a government agent,
And someone who's been a government agent in the past even, or is an ongoing government agent in other cases or involving other people, is not necessarily a government agent against a particular person unless there's...
So your point is, it doesn't really matter what the terms of the agreement are, because unless it was to target Murphy, I mean, you keep saying, no, he wasn't targeting anybody.
Right.
But what you've just said to me doesn't matter even if he was targeting somebody else. If the agreement didn't say, see what you can get about Murphy, I don't have a government agent. Is that the Commonwealth's permission?
If the agreement was, see what you can find out about Brown, and he found out stuff about Murphy. If the agreement was specific to Brown, not to Murphy, he's not an agent about Murphy.
Okay, so but that explains, if that's the Commonwealth's position, it doesn't matter what the Commonwealth's position is, it doesn't matter what the terms of the agreement were. If they didn't mention Murphy, he's not a government agent for purposes of Murphy.
Right, and the second fallback, if, the feds are rather hardline, even the ones who don't apply the bright line test. But we don't even have a circumstance here where he has an agreement to find out information about anybody. But the feds have said, a bald thing about find information about anybody isn't enough to be an agent. But even if this court was going to construe things more narrowly, you don't have this here. Wilson testified nobody told him to go after Murphy. Nobody told him to go after anybody. Nobody told him to get information about any inmate in the jail. There is no other evidence to the contrary. The written cooperation agreement isn't to the contrary. That's what we have. He did, and the second prong is, did he deliberately elicit? Murphy had already given him quite a bit of information before he asked a clarifying question, what did you do next?
Had he got information that he'd killed somebody?
At which point he said he killed him.
I don't think it's
Well,
clarifying.
he tried to get him to to silence the identifying witness to the murder by bribing him with a marijuana. And he'd already told him about his relationship with the person who the defense now is saying is the true culprit in Mr. Smith's death. But that one question, a single question like that, the federal authorities have not found that to be deliberately eliciting when it's part and parcel of a conversation that's not really being orchestrated by the informant.
Thank you, Ms. McMahon.
Thank you.